Things are getting worse today.
I don't want to be another Pompeii. Worried. It's bad, eh? Yeah, it'll
Yeah, but it's but today, you know, it's hard.
Guys, if you're ready, we can continue. I'm just going to show you a few websites you can go and have a look at to get more information. Because as we've already established, it's terribly technical, and so you can go and play around on these sites to get a better idea, because it's impossible for us to discuss the specifics. So my primary goal is for you to start thinking about the stuff, to be aware of it, and to just point you to where you can find more information regarding it. This is just something that explains very briefly and in a truncated way how the Patent Cooperation Treaty works, for instance. You would use this if you would like to protect your patent outside of your national jurisdiction. If you would like regional or international protection of your patent. So this is one of the options, the Patent Cooperation Treaty. It's administered by the World Intellectual Property Organization. And you'll see here, it explains more or less what it's all about in relative simple language. So if you have a nice look at this and read through this, you'll understand it a little bit better. You'll see that there are 145 contracting states to the Patent Cooperation Treaty. So the protection is quite wide. So it explains the process in some more detail. You see they give you more or less time frames in which it, although these time frames are not set. If you, for instance, file an international publication and then go on to the national phase, it'll depend on the national office. Because some countries potentially take years, others are quicker. And that will also depend on whether it's an examining system or a non-examining system. Most African systems are non-examining systems. They're thinking about changing South Africa's system from a non-examining system to an examining system. Now, it's a huge debate whether that's a good idea or not. Because the simple fact is that it takes a lot of resources. Apart from, if you just think about it, if you need a lawyer to draft a patent application, the specifications, especially if it's a technical process, like chemical engineering or even software, you need experts in order to understand what it's about in order to draft the specification, because you need to be really specific. Now, the reason why most African countries don't have an examining system is exactly for that reason, because it takes a lot of resources, it's expensive, because you need to pay people that have the expertise to be able to examine the patent. Never mind patent lawyers. So that's the reason why in Africa we don't generally have a patent examination system. Can you see the logic behind that? But what happens is when other more resourceful jurisdictions like countries in the European Union or America, Japan, if they want to file international applications or protection applications in our countries, what we then usually do, by the stage it reaches the African Patent Office, in whichever national jurisdiction you're talking about, that patent has already been examined. Well, most likely so, because it's already been through an examining office in, let's say, the United States or Japan or whatever. So the African patent attorney would then just basically file the same patent in its refined form, so to speak. The problem is with a non-examining system, if you file a patent in an African national jurisdiction, which is a non-examining system, and you want to file it in an examining system, because then you need extra expertise because your patent is getting examined. So it's a bit of a lopsided affair, to be honest. So you can go through this. I'm not going to go through it in too much detail, but you can read through this and you'll understand it a little bit better. And if you want to really consider doing something like this at a later stage, this will give you a good idea of what you're dealing with. You'll see they also provide well, estimates of costs and stuff like that. But what it costs you will really depend on where you decide to file it and how far-reaching you would want your protection to be. Just a term that just want to point out is the priority. Your patent, when filed, is obviously not granted yet, because depending on whether it's an examining or non-examining system, even the non-examining systems, you're not granted the patent the day you file it, because it still needs to go through all of those administrative processes. But let's say the patent is granted 6 months later or 18 months later, depending on the system. Then it's regarded that your patent is valid from the date you filed it. So it's basically retrospectively. Yes.
What's the day it's granted?
The day it's granted is the date that it's valid, but it's deemed that your protection started the day you filed. So let's say you filed on the 1st of January, you filed your application. At that stage it isn't granted yet, so you don't have effective protection. But then it's examined, or it goes through the processes depending on the system, in which the national jurisdiction in which you file. And let's say 6 months later the patent is granted on the 1st of June. That's the date it was granted. But it's deemed that your patent was valid from the 1st of January, the date which you filed it. So you have retrospective protection. You understand that?
Yes.
And the same thing with the national filing and the international filing, because it's two different processes. So if you follow the one process, then the priority claim is basically at the end of the second process. The priority claim says that the effective date was when you started the first process. That's the priority claim. Here I talk about the searches. I'll point you to some websites now that will explain the searches, or that you can turn to, or even tutorials of how to conduct the searches. So yeah, you can read through that. They also provide you with some nice links. You'll see that there's a separate website as well with a nice application guide if you decide to go this route that would be a good place to start. That even if you appoint some legal people to help you, it's always good to be part of the process and to know what's going on, to ask the appropriate questions, or because sometimes lawyers talk a hell of a lot, that I'm doing the past 2 days, but they don't always share with you exactly what they should. They're not open and brief about it because they would like to charge you for another 3 hours extra to keep you in the dark. So even if you appoint people that you think are experts, it's always good to have a basic knowledge of the process you're busy with. Because then you can ask appropriate questions and you will probably save a bit of time and money. And because being part of the process, even if you don't have the technical knowledge of what you pay that person to do, but to have a basic knowledge, to have a basic background, always helps. Makes it a little bit safer and potentially a hell of a lot cheaper. So if you want to go the patenting route, just read a bit or read as much as you can so that you understand the basics. Trisha, where do I get to the other?
Click on the page.
Oh, there we go. Okay. Now, here are the examples of the 2 African regional intellectual property organizations. The first one is a repo. Now, there you can see it stands for African Regional Intellectual Property Organization. Now, essentially, there you see the countries that are part of a repo. A repo sort of bundles together some southern African nations in this organization. That one we'll be looking at after this, UAPI, is more than central to northern parts of Africa, the French-speaking nations. We'll have a look at that one now. You can also find some nice information on here. If we can just have a look here. Oh my goodness. You'll see they explain what the repo is all about and the reasons. As they state there, because we do have a problem in Africa with capacity. It's a huge problem. So the idea behind these organizations is that they pool resources. But even though that's the idea, it's not happening in a sufficiently enough manner. So a lot of work still needs to be done. The idea is also to coordinate the laws, which isn't really done effectively. The idea is to not duplicate, so to speak. Instead of us all doing our own thing, let's do the same thing and do it properly. That's the idea. But I don't think it's happening effectively enough, to be honest. But that's the idea, to harmonize the laws. But in Africa, up until this time, as we saw yesterday when we looked at the statistics, for instance, I wouldn't say it's not a priority for us to protect our intellectual property effectively enough. It's just in Africa, the reality is that there are other priorities that are more important. So our governments, for instance, would rather legislate other things that they deem more important. And we're not paying enough attention to stuff like this, or we haven't up until now. I think the realization is slowly setting in that we really need to pay more attention to it, to coordinate our laws, to really get them up to an international standard, but up until now it hasn't really happened. Although organizations like these are definitely steps in the right direction. Here's the other one, Oapi. There you can see it's sort of the region of the, more or less the countries that are part of Oapi. And you can have a look at,
Nigeria is not
What is that one?
what is that?
Nigeria is not as big. I'm not jealous, but Nigeria is as big.
We must just maybe drop them an email, anyone, that they just need to check their spelling.
But that's French. It's a mix.
It's a mix.
It's mixed, that's French, yeah. Ressource. Is that how you spell it?
Because this is all English, okay, there's French.
Because contribution au développement, formation, ressources.
It's
It's a mix.
It's a
I
mix.
know that Nigeria is at the
Nigeria,
east of Benin, but
Nigeria, can you see Nigeria?
it's not that country.
Nigeria don't like this kind of
Nigeria is
thing.
not part of
Protect.
But
Nigeria
they are
don't
part
like
of
this.
the approval.
You don't understand that.
because I don't
Guinea is
Even if
there.
they are part of it,
see it in
the
grey color.
bureaucracy.
This is for the French-speaking countries.
Yeah, that's for the
Yeah.
mostly
I know,
French-speaking
yeah,
countries, yes.
I know.
Nigeria
It's
is
based in Cameroon.
What is it?
I think the other one is
Nigeria is
based in
a
Zimbabwe.
French-speaking country.
Well, it was conceived in Zimbabwe, yes. It was part of the Harare agreement, yes.
Yeah, I think it's in
The
Zimbabwe.
headquarters in Zimbabwe is in Harare.
Yes, yes. But
The members, yeah, I would like to see the member states.
where?
It's on the right. At the
Oh,
top.
there it is, yes. Okay, let's have a look. There we go, Benin.
Where's the English?
Guinea is there?
This can be French. Look.
Okay, so just French speaking countries.
French-speaking countries.
Around the northern
Anything
ones,
apart from
Oh,
English.
Senegal is
like
there.
Tunisia.
Yeah, Senegal.
Yeah.
Google will translate. Okay, frequently asked
They haven't
questions.
signed it.
No,
Because
doesn't
they're
seem
not
so.
part, they're not member states of
That's
our
French.
group.
No.
The language is important in law
Yes, the language is also terribly important in law.
because I feel that I remark that we have a French organization, the English organization, the international organization.
And because the law is not different, it is not the same.
It's
Like
not
you have
the
the
same.
civil law
Yeah.
and you have the common
That's
law. They're
segregated.
based on two
Different-
different families, law families.
Yes, law families, the two different systems that form the fundamental basis of that system is they talk that it's the civil law and the common law basis.
Like the OIP, they follow the
Yes.
French law.
And the French law is based on the civil law system.
Exactly.
Yes. But language is important, and that's another obstacle for patent filing. If you want to register an international patent in a jurisdiction in a different language, you'll need to have that patent specification translated into another language, which is also, if it's technical in nature, could be quite expensive to do. Because if you're talking about technical terminology, and that's another sort of drawback for, let's say, non-English speaking countries, to file an application in America or in the European Union, or because you could possibly have a patent relating to nanotechnology or chemical engineering, and then you'll need a chemical engineer patent specialist in that language to draft the specification.
It is possible to patent nanotechnology in Africa.
It difficult.
It would be difficult. One of my students wrote a master's dissertation the other day, and I didn't understand a word of. Because I understood the law, but how the arguments were stated, because it needed to apply the basic principles of nanotechnology. It was just impossible for me to understand.
It is a time to do quickly. Because you don't know.
I don't get it.
You want to get it in Africa?
International.
I think now in nanotechnology, because you don't know nothing. So yes, it's good, but it's
So there's no another one.
You see, it would in theory be possible, because we must always remember,
The documentation.
Well, no,
we must
there's
always
no-
remember what we're dealing with. No matter if we're dealing with some or other chemical process, software, nanotechnology, we always need to go back to the basics. And that will tell us whether something is patentable or not. There are the definite exclusions, like a natural discovery or a mathematical computer. You know, there are some definite exclusions in most national patent acts. There are a number of exclusions, but if it's not a definite exclusion, then it only needs to fulfill the requirements of patentability. The novelty, the non-obviousness, the fact that it must be able to work in trade. So if a nanotechnology, to answer your question, complies with all of those inherent requirements for patentability, then in theory it is possible to patent nanotechnology in Africa. Yes, to answer your question.
This one is not only for Francophone. You have got Guinea Equatorial and Guinea-Bissau as well. So
But Guinea Equatorial, they decided to become members of the Francophonie.
since when?
Oh, no, long time.
ago.
Yeah, but they don't speak French.
No, they do. They do not.
They started.
Yeah, the elite speaks French.
But so this
some
is
people
a
do.
member of the Francophonie or Francophone countries? Because it's
Francophone
two
country, but
different.
because you said the Guinea
Member of
Equatorial is
Francophone,
not a
it is.
Francophone.
Equatorial Guinea?
But yeah, Equatorial Guinea, they speak French.
They
I've been
decided.
there. They speak Spanish, first language, but they speak also French.
So can someone tell me why it's called Organisation Africaine if it's only Francophone countries there?
I've
Do we have another one for Anglophone or
Yes.
is this the only one?
Yes, yes.
We were talking about
I'm a bit tired.
We understand.
But Africaine, c'est
Agricole.
encore toujours tout le
Agricole is for the Anglophone countries.
The what?
Agricole, African regional
Ah,
intellectual
okay.
property.
how this organization work to
We
know
should have
that
that one as
this
well, no?
is not
It's on
patent.
the
It's-
For research.
Right.
The other one. We talked
You
about
make
it for
comparison
15
of
minutes.
every
Yeah,
document
yeah,
that is
yeah.
not patent in this.
to see
They
that.
have a good database normally.
Yes, they're supposed to, but it's remember it's
Talking just in detail.
remember it's not necessarily the organization itself. It's just the organization coordinates the efforts to standardize the laws, the processes. So it's not the organization itself that they don't have a lot of people sitting there examining patents. That's to be honest, neither one of the organizations have that capability. They don't. They just simply don't. The idea is that they coordinate efforts in order to standardize the laws and the processes and make it easier as a collective to do things internationally. I'm not, to be honest, convinced that they're so successful at this stage of getting, of reaching their goals that they set for themselves. But at least it's sort of a great idea to move things forward, but a lot of things still need to be done. For instance, in most of the countries forming part of either one of these organizations, Reaper or Harpy. To be honest, there aren't really in any one of those countries that form part of any one of those organizations that are able to draft a patent specification that would be patentable in an examining jurisdiction such as the European Union or the United States or Japan. What usually happens is that in practice, these organizations have a database of lawyers, because most African countries are non-examining. If an American company would like to register a patent in any one of those countries, it already went through the examining stages of the American Patent Office. So they basically just refile the exact same patent, and basically all that this organization does is they have a database of lawyers in that country or contacts in that country that file the exact same patent application. The lawyers in those countries did not draft the patent specification. And that's where our problem in our continent lies. We don't have the expertise yet in any one of the countries listed in any one of those two organizations are able to draft technical patent specifications. And that's the sad reality of it.
What is the minimum time or the maximum time to patent something?
There isn't a minimum or a maximum time. Remember, one of the basic requirements for patent is novelty. So that's the basis of it. So as long as it stays novel, and novelty supposes that the public doesn't know. Now the public is, as I said, has a very specific definition. As long as it's not out there, as long as it's sort of secret, so to speak, then there's no time limit on it. So you can patent it whenever, as long as it's not part of the state of the art, which means the knowledge base of what you're trying to patent.
It is the collaboration between all these organizations.
There isn't really, no, unfortunately not.
But how can he know that the thing I patent in Africa, it is not patent in Asia, or it's not patent in US?
That's why before you patent something, and when I showed you the Patent Cooperation Treaty, the frequently asked questions, the part of the process when you patent something is they do a preliminary search, a patent search. And you did? No, usually the lawyers do, but you can as well. I'll show you a few patent search tools. But usually the lawyers do, and they do a preliminary patent search to determine the state of the art. And that's what I said earlier as well. It's important for you guys to be up to date with your industry, to know what, to use the technical term, the state of the art is. State of the art refers to the base of knowledge that's already within that particular discipline. Because there's no sense in working on an idea that already exists somewhere totally different. And you think it's novel, and you think it's non-obvious. Because if you want to file a patent application in the United States, for instance, with different systems use different terminology. Some speak about novelty, which means it's new. Some speak about non-obvious. Now, you might think that something is not obvious to you. But it's only not obvious to you because you don't know the state of the art, so to speak. You're not up to date with the current state of knowledge within your field. So you might think something is totally new, and if you file that patent application, the examiner might say, but this is so obvious, we've known this for years. So usually before you file the specification, either yourself or the lawyers will do a preliminary patent search to see what the state of the art is, dealing with that. And the patent searches are, you get easy, short ones, you get really intricate ones, but the searching tools nowadays, the databases, are very well coordinated. So it's possible to some extent to determine the state of the art if you use those search tools effectively. Of course, the examiners also do that. Before they put the rubber stamp, so to speak, on a patent, they do searches to see whether this doesn't exist already within that particular national jurisdiction. So a patent search is an integral part of the process, very important part of the process.
So, if an American company come to one of those countries to register their patent, they bring their own kind of, everything is already written. We don't really have a regulation to tell them this is how you should do it.
There are some technical regulations depending on the national law. You know, how the patent must be set out, stuff like that, but it's more administrative in nature. What they bring is basically what they call the patent specification, the technical part of how they explain exactly what it is they patent and how it works. That they bring over, because we don't have the expertise to do that.
Well, as long as we have our own regulations.
Yes, depending on the system. Each national jurisdiction have their own rules, but that's usually administrative in nature. How you must file it, how it must look, what you must pay, stuff like that. But the drafting of the specification itself, unfortunately at this stage, we don't have the capabilities to do that.
None of the countries.
South Africa does. Yes.
1 of 55. 1 out of 55.
South Africa does. You'll see that South Africa also, even in these countries, the big law firms in South Africa would represent the big international companies, and they would basically do it via South Africa into these countries. So it's sort of in a roundabout way.
Well, we have a lot to do.
We have a lot to do, you're absolutely right. But I mean, Africa is going through such an exciting growth phase, and international companies are setting up offices in, you know, so many different countries now that previously in history, you know, we didn't see.
Yeah.
So the expertise will definitely be needed, and as this trend continues, we'll definitely see expertise in all our countries being refined. Of course, the companies want to, as we've seen during the past 2 days, the international companies really regard their IP as terribly important. So if you want to do business in Ghana, for instance, you'll make sure that you have protection there. And if you need to take your own guys there, or to train people there, you'll do it. So as Africa develops, and it's growing faster than any other continent at the moment, it'll take time, because these things happen over a long time. But it's in our future. I believe that very strongly.
Keep positive, I like
Yes, we should be.
You want to check it? You want to go for?
I just want to just look at the patent searches very quickly. Maybe we can go to the US Patents Office. They have nice links to some other patent searches and stuff like that. So it's just USPTO.
all of us, that's generalizing.
Oh, your friends are bankers. I can never trust bankers if they belong to.
Yes. Yeah.
I hate it.
My yes, no, .gov, it's fine. Yeah, you can just go there, I'll find the links. Okay, let's go there. Thanks. Okay, thank you, Tricia. Yes, I'll go there now. Guys, there are lots of information regarding all of these aspects we touched on everywhere available, in books, articles, and as we all know, especially on the internet. So the idea with this workshop was to introduce you to the principles, but I can't teach you the specifics in the time we have. You're not lawyers, you're not supposed to know the exact theory behind it. You just need to develop a basic appreciation of what's relevant. And then if you want to know more specifics, you can go and search for it, and we can all read. Then you can go into more detail. I just want to point you in the right direction and create a little feeling of what it's about. There are lots of information on the internet, so if you're interested or you, during your journey, reach that point where you need to deal with aspects like this, or it's relevant to your project, then at least you have a basic appreciation of what it's about and you know where to look. And a site like this is wonderful because it provides so much information. Like inventive frequently asked questions. It's not as legalistic, but you find great ideas and pointers there. Now you see there are patent search tools. If you go there, they provide a strategy if you want to conduct a patent search. You see there are quick searches, advanced searches. There's even a global patent search network. These systems are unbelievably interchangeable. If you actually go into them in detail, it's amazing what you can find. The detailed information, it's just an amazing database of information. Now you see there, you can do a global search there are search facilities for patents in general, certain regions, internationally, and then also you can search in individual jurisdictions as well. So if you want to patent your whatever it is in your national jurisdiction, and you have a plan on maybe you have a joint venture with someone in a specific country, or you plan on taking your product there or developing it there, exposing it there, then you're able to search a specific country's database. For instance, Margie might be interested in France. then you can search the France database, and so you can, for instance, the Japan Patent Office, that might be a bit difficult. So we won't go there. But if you play around, you'll see there are so many databases with so many search facilities that it really boggles the mind. So if you're interested, just play around a bit and see. And there are also tutorials.
In search, is it keywords, names, or what?
They have different ways of searching. They have categories. They have terminology. They have numbers, years. You get quick searches, and then you get very intricate searches where you can put in real specific information. Wow. This thing is really sensitive. I think I'm getting there. I just want to show them this. It's a nice little tool. It's let's see. IPR help desk. Oh, that's probably why I didn't put that little one in. Help desk. Let's see if we can get there. Yeah, it's all right. Thank you, Patricia. On this side, for instance, there's a tool that you can find that, well, it's a little tutorial on how to do a pattern search. So it'll show you the various different quick searches.
IP help desk dots.
IPR, help desk. There are some nice pattern search tools and stuff there.
.eu.
And then another site that has nice information that you can play around on with some nice patent resources, especially for the software stuff, is www.softwarepatent.com.
Software.
patent.com.
I wanted to ask what legal implications there are in terms of maybe what we're talking about, trademarks and IP rights and copyrights in the open source world.
We'll deal with that
Okay.
this afternoon, yes.
Okay.
We'll deal with that later this afternoon because we're going to start with copyright now. And then we'll discuss open source and Creative Commons and
Yes.
very briefly have a look at that. That's sort of the last part of our program.
Awesome.
Yes. So before we step off the patents, any questions, any debate you guys would like to get involved in?
In getting a patent, is there any other intellectual property, other ones you need to register for a product? Maybe if you are patenting a lotion, as we discussed yesterday.
Yes.
So you need to get some other ones to make your whole product. So not just.
Yes. As I said, you should view it as a basket of rights. And whichever right could be applicable, you need to protect. Because even for software, a trademark can be a very important tool in protecting software, even though it has basically nothing to do with software, directly speaking. But it's a terribly important tool to protecting your software by an indirect manner. If you just look at Microsoft, for instance, the biggest value is in the trademark. But what do? They develop software. So you should think of it holistically. So if you're a software developer, please also remember your trademark, because that could be one of your best forms of protection. Your name, your identity, your goodwill, because that's associated with your brand, your mark. Can even be more important than your actual product. So it's very important. It's very important.
So you say the patent applies from the day of filing, if it is granted, right?
Yes.
Now, if later someone...
Remember, the effect is only retrospective.
Yeah.
Yes.
So if someone later finds out that this knowledge already existed prior to the filing, how is that handled? Like if someone was already using that knowledge to produce something previously, only that during the search and during the patent process, it wasn't discovered. Or you are in a different
country.
You are going to file in a different country, then you
Yes.
find out that the knowledge was already used prior to the filing. So
It is one of the grounds you can attack a patent on. It's not the correct technical terminology, but there are grounds on which you can have a patent invalidated, so to speak.
So it becomes invalid.
Well, someone will first need to apply to have it invalidated, if it was granted. And there's also periods in which a patent application can be opposed. Because it's published, before it's granted, it's published. Or even after it's granted. Because every patent is published in a patent journal by the patent office in that jurisdiction it's granted in. And interested parties can then have a look at the patent journal. That's what the big companies do. They have lawyers that go through all the granted patents. And if they see there's something there, then they attack that patent.
In publishing the detail, is it an abstract of the whole document, or the whole document has
It depends from system to system. They apply it differently. But it's usually, you can access the information to see the detailed specification. Because especially, you know, the very technical things and these big companies, sometimes it's just a very, very small little thing that differ.
Okay.
And it's that's attacked. So that's why, you know, these big technology companies, as we all know, spend millions and millions because they try to convince each other that it's their patent. No, it's mine. You stole this. No, I did this.
Okay.
So it's actually a bit of a circus the past few years because they're spending billions. That's why we're paying so much for their iPhones and all of that, because they're litigating each other to death.
So my question was, so if
Yes, sorry.
if the knowledge was being used prior, and the patent, then you realize that someone has found a patent for it. Do you go to invalidate the I mean, is the people who are using the knowledge, are they allowed to go scot-free, or do they have to start paying royalties to the...
You see, it's a question of practicality. You will only attack a patent if, or try to invalidate a patent if you're harmed by it. If you don't do business in that particular jurisdiction, or even if you do, but the patent doesn't harm your business because it was incorrectly granted, because it was already part of the state of the art, there's no need for you to attack it, to try and invalidate it, because it doesn't affect you in any way. You will only do so if it affects you. So it's a question of practicality, of fact, whether the circumstances of that particular case warrant you to try and have the patent invalidated, because, and that would be one of the grounds.
Okay, in the practical sense, I have a product I'm selling to the US, then I find that it's patented in the US, so I either pay royalties to the person who patented it, or I just don't sell it in that market. Is that?
Yeah, well, that's a question of practicality again. You need to, that should be part of your strategy. You either decide to pay royalties through a license agreement you conclude with the other party, or you take the chance of ignoring their patent and selling your stuff there, but then you're taking a huge risk. Then you might get interdicted, they might confiscate all your products, and you will be liable for damages.
Which the Americans are so good at.
Yes.
They'll wait for like 3 years for you to sell.
Yeah, and get all your money back. Yeah, it's horrible. Oh my God. Oh.
Like the Monsanto example, they very aggressive enforcers of their patents. They go all around the world. And they litigate in foreign courts to enforce their patents. The figure, I don't want to lie to you, but I read an article the other day when I was doing some research about what they think, and it's just what they think, because the numbers aren't sure, because Monsanto doesn't want to let everybody know every case they pursue. But it was something more than $100 million, which they have already received in damages.
Whoa.
In various different jurisdictions over the world by just enforcing their Roundup Ready patent.
But then,
Just the one patent. It's what they earned, not out of sales, not out of anything else, but damages. Damages that were awarded to them for patent infringement. More than $100 million.
so then, do they register their patent in each country?
Yes, they do it the way we've been talking about now. In different regions, in different countries, they would, because they have these huge budgets, they would basically register it in every national jurisdiction that they sell their products.
What they make?
Billions of dollars.
No, I mean, what are the products?
They make a seed.
Seed.
Ah, the seed. Ah, okay.
Yes. That article I gave you
Right,
explains
yeah,
it
yeah.
in short, yes. So they enforce their patents terribly aggressively. So they're actually making money out of enforcement. Not out, well, mostly out of the patent itself. But they're actually making millions of dollars out of enforcement of their patents.
Why people are dying?
What do you think about the fact that some people think that patents kill innovation?
Yes, it does to an extent. I agree with that. Depending on which view you take. Because it's not a, again, as many of the topics we've discussed, it depends on your angle, which side of the fence you're on, and at which specific argument you consider. But I agree with you that in some respects, patents do kill innovation. But not in all respects. Because the whole idea is, as we've said when we've started, it's the whole premise behind it is to encourage innovation. The whole idea is it says that if you innovate and you're successful, we'll reward you for that innovation. So that's the basic premise of it. But the way the system works in practice, it also to some extent hinders innovation. Yes.
I was reading the other day, was it Volvo that invented seatbelt, but they give it away? Because before it was quite, it's for the security of people. So they don't really want to get any money out of it. So they give the secret or the patent, I don't know what they gave away to people. It was quite, I thought that was amazing.
Yes, you see, that's the big political argument regarding patents worldwide. Especially for Africa, if we look at, let's say, pharmaceutical patenting as a good example, because that's with our whole AIDS epidemic and stuff like that, it's a very hot topic. Because the pharmaceutical companies take years and a lot of expertise and a lot of money to develop those medicines, like the antiretrovirals, for example. But they still want their cut of the pie. They charge exorbitant amounts of money. Now, the political argument is that they should at least provide those medicines to the less privileged, especially in Africa at a lower price. But they don't. And there's a term in patent law they call compulsory licensing, where it's sort of a political decision to force a patentee to provide the patent, the knowledge of the patent, at a reduced cost, or for free, or whatever. Although that's a very controversial thing to do. In South Africa now, they published a new intellectual property policy end of last year that was terribly badly drafted, and I don't mind saying it on the record. But our Department of Trade and Industry has this whole new way that they want to deal with the pharmaceutical industry. And it's a very dangerous thing to do. Some of the arguments make sense, but it's a very dangerous thing to do. And then you also get what they call evergreening, and that's also a very prickly subject for many people, because the patent, as we said, lasts for 20 years. And then after 20 years, it's possible to make a generic version of that product. Now, what they do is, when the 20 years are over, they just change something very small, and they just carry on like that. So, yeah, all of these things are terribly controversial, and there aren't easy answers. Because it's, philosophy, morality, the law, everything. Some of the arguments make sense that we need to, remunerate people for the work they put in, the innovation, the money. But on the other hand, there's a question of morality. There's a question of like the Monsanto argument as well, food security in Africa. And it'll become worse and worse as we go along, because inventions would, change humanity in ways we can't imagine even now. So it'll be relevant for forever, I suppose. And to find a balance is terribly tricky. I don't know.
I think it depends on the company, right? Because Volvo did it because the food was for health and safety to save life.
Yes.
And if other companies that, food thing like they care about people dying and stuff, they could do it, but if they don't, money is more important to them, why they go that way? So
yes.
That's a low argument.
Huh?
This issue of moral and business.
Well, I think you have to take a side. That's it.
You see, it's a very difficult thing to do, because with both the examples I've handed out to you, those companies spend billions of dollars developing those products. And now they want their payback. They want their payday. But it's a moral question whether they would rather receive their payday but potentially let thousands of women over the world die of cancer. Or the Monsanto, just, they...
But then people can decide to sue them for that.
No, they can't.
Sue them.
That's because they're not directly, it's not the form of a delict. They didn't do anything to cause it's cancer that does it. But they could have to some extent prevented it, but they did nothing illegal. The same thing with the Monsanto. Within America, their own people, not even in a different continent. In some of the regions of what they call the agricultural belt in the United States, we're talking about their own people. They're so aggressively enforcing their patents that they're putting some of their own farmers, thousands of their own farmers, out of business, basically. And they're doing it in Africa as well. Then you get that humanistic moral question. Would you rather let people die of hunger
than being rich?
But if they don't get their money, then we won't have the next round of ready seed.
Yeah, but it's one
so
thing.
it's a terribly difficult.
It's one thing having the money. Wait.
That's
It's
a
one
false
thing having the
argument.
money invested and live on that.
And still had the knowledge,
And
right?
another thing, making billions.
But you see, for them to produce the next knowledge, the next product,
It's too greedy.
they need the money to do it. They need the money to do it. They need to invest billions
That's what I'm saying.
of dollars with research facilities, people, skills. It takes years to invent something like that. Because that seed, it's something simple, but they changed the genetics. Now, I can't even start to think what they did to change the genetics of a seed. It must have taken so much input, and to invent something like that in future, they need the money back from what they invented in the past. And that's the argument.
Yeah, but then there is a limit, right? If you get the money back,
That's the
you don't
point.
need to be 6 times richer. But come on, what is business? Human people,
What is you are saying what is business if people are dying? But what is business if your government are using the money to buy big cars and people are dying?
That's another thing.
See, that's
Don't go into that. Don't go into that. No. Don't go into that. That's another thing, okay? That's another thing. Let's not venture that road, okay?
No.
That's another thing.
They can pay for the same thing.
Yeah, but we're not going there. We're not going there.
Yes, that's what I'm
See,
saying.
that's a political question. It's not a legal or moral question.
Yes, they meant to. Yes,
They have to make,
yes.
if they are going to survive or stay afloat, they need to make profit. That's the primary essence of a
It's
business.
one thing making profit, another thing making 6-7 times that profit while people are dying. I'm
Well, it depends on how you
sorry. It doesn't make
it
sense
depends on how
to
you
me.
interpret it. Look,
Oh,
yes,
really?
it does.
So,
The business was primarily set up to stay afloat and survive, make profit. You cannot take our morality after.
I'm not saying they, I'm not saying that.
I'm talking now as a businessman.
Yeah.
I can't be taking up our morality when I'm going to crash tomorrow. I'm possibly to survive.
I think we're the only one risking.
When you are investing, when you invest money on those things,
Okay, guys. I'm very glad that our discussions.
This is the kind of thing that you can sit down.
No, it's wonderful.
You can't tell me that
It's wonderful that you guys have so many passionate views about it, and that's good. That's what discussions like this should be like. It should make you to start thinking about these stuff. Because you deal with the reality and you deal with the philosophy and you deal with the morality of it. And it makes you think about it, and you then deal with the reality. And our reality in Africa is that we can't expect other people, even if it's about lives or food or security, to always sort of help us because they're able to do it and we need the help. We can't point fingers if we can't do it ourselves. And that's what I'm trying to say, is we need to, even if it takes us how many hundreds of years, but we're starting to get there. Discussions like this, people with projects like you, we're starting to get there. We need to also become a part of the inventors of this world, so that we can also have products which we can sell to them. Then we wouldn't need to worry about stuff like food security and always looking in the eyes of other people to look after ourselves. That's the reality of it. We need to change it somehow, sometime, and discussions like this is good because it makes us think about the reality of things.
But for me, there's one thing we need to think about as Africans, taking example to other countries. We could make money, but at the same time try to, to have that humanitarian side at the same time, not just think money, because we have to learn from what others are doing and putting few things into perspective. Thinking, okay, I could make money by doing this bit, but besides, I could, do something beside that could improve, people's life or something like that. For me, that's how I want us to think, and that could help
the way
us.
we should think.
Yes. That's what it should be as a new generation, not just saying, we have to make...
Exactly.
Yes.
Can you do CSR without making profit?
Yeah, but no one has said that.
You can
make
reach a
profit,
balance.
guys. Don't see the same. You have to... No.
There should be
See, altruism works. It makes sense.
Let me say that every young company I advise, I tell them that as young as you are, you should be able to incorporate some corporate social responsibility into it. If you wait until you start making big money, you can't do it, since you can't do it from the beginning. And that is very, very important. Every young company should, at least you don't have to do it very big, but start it. However, your corporate social responsibility can be sustained if you make money.
Yes, exactly. That's the way to view it. It's a very good approach to that.
If you want to be so social and your company collapses, nobody will remember you.
No, it's true. But again, guys, that'll totally depend on your product, your innovation. As I said, there aren't any. We can't look at this with blinkers on and pigeonhole it or however you'd want to express it. I just like the way you're thinking about the different views you can take, the different perspectives you can have. It will obviously depend on the circumstances of your particular environment, of your particular product, but these are all things that you need to consider going forward. Because there will be different perspectives to each of your businesses. And as long as you start thinking within the specific context of your business, about the different ways of doing things, the different considerations that are critical, then all of your arguments are valid to some extent. Some of you might have a purely humanitarian view on it. Some of you might want to share, because let's take patent software for instance. And that's the whole thing regarding open source as well that we'll go into a bit more detail later. Sometimes it's good for your business from a strategic perspective to provide your source code to someone else, because people collaborate. Then they add value. Whereas if you had a different invention, it might not be the correct strategic option to share. It all depends on the circumstances of your particular case, of exactly what invention or product you're working with. But it's good that you start seeing the different angles you need to look at your business. Because every one of your ventures differ to such an extent that it'll take a unique strategy from each of you to make certain key decisions. How are you going to protect? Why do you protect? So many different angles. You need to consider them to find the best solution for you.
I have a question.
Yes.
You said earlier on that the patent period is 20 years.
20 years, yes.
Yeah. Is there a possibility that in one of the territories you have the ceiling as 20 years, and depending on what you're applying for, you're given, say, years between 20 and 0?
No, it's usually the international patent system usually works on the flat. Yes, but as I said, and you guys need to remember that the protection, even if it's granted, if the patent is granted, in theory it's for 20 years. There are, every individual jurisdiction have renewal periods. So when it's granted, it's not yours for 20 or valid for 20 years and that's it. You have renewal periods, and those periods and fees for renewal, sometimes some jurisdictions, those fees escalate. Sometimes they stay the same, the fees differ, the renewal periods differ, but that's something you must also remember. If a patent is granted, there are renewal periods, and that's important. There's no use in having a patent, but you don't renew it. So if you go that route, remember to renew your patents.
Because you can work with such kind of scenario where you're giving fewer years for the humanitarian.
Yes, well, maybe that's something to consider for the big guys making the big decisions. But remember to renew your patents. No use in getting one, because it's basically, they don't examine it again. If it's been granted, it's granted, except if it's attacked or invalidated. But if it's granted, it's granted. You just pay a fee to keep it valid.
Okay.
So it's not a whole new application. It's not a whole new application. It's just like renewing your driver's license type thing. You pay a fee, and it's then again valid for that period. And the period it's valid for before the renewal is the next renewal depends from jurisdiction to jurisdiction. So in whichever country the patent was granted, you need to make sure what the renewal period is.
Okay. So in an event, is there a period when you don't renew? Another person could go in and maybe modify it and patent it. Maybe after 2 years
Yes,
without
it's practically speaking, it's possible. Yes, practically speaking, it's possible. Okay, anything else on patenting before we step off of that?
Is the moral against the
it's
fine.
We're good. He gave me some, some stuff that, now it's fine. It's good.
Okay.
I never said, I don't know if you guys understood what I wanted to say. Like, not long ago, I met with a young African. We were talking about different projects we all want to do in London. And I was telling them that I wanted to, since I was primary school, my country has got a lot of fruit, mangoes, orange, and all that. And I thought it's such a waste because when it is a season, you go all over. It's like you see mangoes all over the floor. We need to have a way to process it because we buy juice from Europe, they bring it, it's so expensive. I said,
yes,
we could do that right away there. And I thought my plan was to make a factory back home and make this processing stuff so we could have people working there, women mainly,
Yes.
that could send the kids to school but also participate to develop that country. But
it's a wonderful idea, yes.
Yeah. more than 90% of the group telling me, why would you waste your time doing that? Why you don't just go get a container of juice from France and bring it, sell it? For me, that's something doesn't make sense. I told them the whole point.
You have raw material.
Yeah, the whole point is not just to make money, but you could make money at the same time, but also creating jobs and participating.
Yes, of course.
So for me, that's what I'm trying to say. Like, you could have a both. If you, I mean, it depends, like you say, of your businesses, obviously, but something like that, you could do it on the ground, not only, you know, using the farmers. You could help those people having more,
Yes.
you know, things, people have a jobs, but also...
No, exactly. You're
you know,
contributing
so
to your
this-
community and
exactly.
you're making such a difference in so many ways.
But at the same time, getting rich.
And you have the thing that you say, so you have
Not that fast.
Not that fast.
You know,
Sorry, just one at a time. You go ahead. Sorry, I'll get back to you just now.
So I agree with her idea, because we have very good and we have excellent. Why you cannot be excellent? It's just very good. So we can get money and also be social responsible. Will be great, wonderful.
Thank
Exactly.
Do it.
Exactly.
Come on,
I'm so
listen.
sorry.
Listen now, okay?
The comments from the friend to Rai, it's not that the person does not think about the local people. The business person will look at the efficiency, the sustainability.
Yes, that's
I'm not thinking about sustainability.
No, wait. I'm not thinking in terms of the mangoes you are going to, it's not a plantation. Where during the off season, you can even manage to have it. So it's going to be seasonal. So the business person look at that. That's what you will be looking
but that's
at.
the thing that how people in Europe do it. How do they have the orange throughout the year?
Yes.
You know what you...
So then, they are looking at the efficiency, which include cost, storage,
Yes, as
and
I
all
said.
that.
Did I say it's going to be free?
No.
But that's exactly the point. There are so many different angles to each venture. You just need to consider them all.
Make something great, like she said. We can, the resource that we have.
We need to stop going taking things the other side and bring. We need to create it here and make
We
money
need
and
to.
help people.
We need to.
So, do you have the factory already?
Huh?
Do you have the factory?
In 5 years.
You want to invest. You want to invest. So
You see?
I'm not ready yet. In 5 years.
You don't need investment.
I will go all of you to put money into it.
Yes, no,
Let us be containers.
Okay, good.
Okay, guys, before we go to lunch,
yes.
before we go to lunch, one last thing. There are some nice initiatives around the world, especially with the internet now, that you can, when you have a patent that's granted, and you want a platform to commercialize it or to sell it to other interested parties around the world, there are some nice platforms that some of it's free, they have different categories. Like if you go to ipexchange.com, it's actually ipexc.com. There are different categories in which you can actually market your patent, so to speak. They have categories there of business, and you can market your patents on there. So it's basically a marketplace for patents. So if you ever reach that stage where you have a patent, or you want to employ a patent for your business, let's say something that processes fruit, these are usually small-time inventors. People that manage to get a patent, but it's something they did in their garage. There are big companies as well, but you'll get nice things on there that you could possibly employ in your business, or if you want to share your patent with, see if someone else maybe wants to buy yours. There are some nice platforms. It's like online marketplaces for patents. Okay, let's go to lunch.
Patricia.